Hello, I am visible and audible to all of you. So, hello everyone. A very good evening to all of you. Welcome to today's webinar on marital rape exemption in India, organized by Legal Vidya. My name is Paras Jung, and I am the HR manager of Legal Vidya, and I will be your host for the today's session. We are thrilled to have you join us as we explore this increasingly critical topic, which is becoming essential for legal professionals and social justice advocates. Building a successful career in addressing pressing legal and societal issues requires a deep understanding of the evolving legal framework, along with key skills, knowledge, and strategies to navigate these complex areas. Just give me a second. Whether you are a law student, a practicing lawyer, or a professional looking to engage with critical issues in legal reform, this webinar will equip you with valuable insights. We will cover the essential qualifications, practical experience, and strategies needed to make meaningful contributions in areas like, for example, advocacy, litigation, and policy reform. Addressing social issues like the marital rape exemption is a significant step toward achieving justice and equity. Today, we will focus on understanding the key legal and social concepts surrounding the marital rape exemption in India, exploring the challenges to its removal, and learning how you can position yourself to contribute to this critical area of reform. It's an invaluable opportunity for all stakeholders to enhance their understanding, improve advocacy skills, and contribute to the broader movement for gender equality and legal justice. Now I am pleased to introduce our esteemed speaker for the today's webinar, Miss Rupali Sharma ma'am. Miss Rupali Sharma ma'am serves as an assistant professor in law at Bhara College of Law, Patiala. A dedicated academician, she embarked on her teaching career in February 2023 and has since made significant contributions to the field of law. Her academic journey began with a BA LLB from the prestigious government Mohindra College, Patiala. She further honed her expertise by pursuing an LLM in criminal laws at Punjabi University, Patiala, where she is also currently pursuing her PhD, focusing on areas that align with her passion for criminal justice and the legal reform. Rupali ma'am's scholarly interests are deeply rooted in critical aspects of law, such as criminal justice, human rights, forensic sciences. Her research endeavors have encompassed a wide range of socially significant topics, including victim support strategies, data privacy concerns, and family violence. Through her work, she aims to bridge the gap between theoretical knowledge and practical applications in these critical areas. Her active engagement in national and international conferences has provided her with platforms to present her research and foster intellectual exchanges, contributing to the ongoing discourse in the legal field. Ms. Rupali Sharma ma'am has published three research papers that underscore her commitment to advancing legal scholarship. Beyond her teaching and research responsibilities, she has participated in numerous legal awareness programs and workshops, reflecting her dedication to community engagement and societal betterment. Her involvement in faculty development programs is her proactive approach to staying updating with the latest developments in legal education and pedagogy. In addition to her accomplishments in law, Rupali Ma'am's interdisciplinary interest in forensic science are evident through her certification in question document and fingerprint analysis. This qualification underscores her commitment to broadening her skill set and integrating scientific methodologies into her legal expertise. Her holistic approach to education and research exemplifies her dedication to nurturing a comprehensive understanding of law and its practical implications in society. This webinar is being recorded, and the recording will be shared with all the registrants. I kindly ask all the participants to keep their microphones muted and cameras off during the session. And please save your questions to the end. A feedback form will be shared during the webinar, so you have to fill that form. Certificate will be provided to those who will fill the feedback form. So without further delay, let's extend a warm welcome to Ms. Rupali Sharma ma'am. We are excited to hear her insights. The floor is yours, ma'am.
Thank you so much, sir. The PPT would be sharing by me, or you will share the PPT?
Ma'am, you can present the screen. Ma'am, you can present the screen.
Okay, sir. Is it visible?
Ye- Yes, ma'am, it is visible.
Oh, good evening, everybody present here. So today we will be dealing with the very critical issue of our country, that is marital rape exemption in India. As sir has very rightly said that this is the very critical issue in our country, so we would be dealing with this issue. Let me share my show. Okay. So today we will be covering these topics like what is the concept of marriage with regard to marital rape, what's the basic difference between rape and marital rape, the status of marital rape in Indian legal system, the constitutionality of marital rape, international scenario, most importantly the judicial attitude, and should marital rape be criminalized in India or not, and lastly we would be having the conclusion and suggestions. So as we move on to the introduction of this topic, firstly we have to understand what is marital rape. This word is made up of two words, marital and rape. Marital, we all know in relation to marriage, and rape is a forceful sexual intercourse. So, if we briefly define this term, this is a non consensual sexual intercourse by a spouse. If we move on to the historical concept of marriage, in our country, marriage is viewed as a sacred, contractual, or societal institution where consent was presumed perpetual. The discussion which we are having today arose from the conflict between the individual autonomy and marital traditions, making this issue a pressing legal and human right issue. So, if we move on to the concept of marriage, for understanding this topic, we need to understand the concept of marriage. As a traditional view, marriage is considered as a union implying the consent to conjugal rights. If we view the marriage, it is a matrimony or wedlock, which is a socially and legally recognized union between spouses that establishes rights and obligations between them, their children, and their in laws. If we move on to the modern perspective, the marriage is recognized as a partnership founded on a mutual respect and consent. As per the ancient Hindu scriptures, no religious rite can be performed with perfection by a man without the participation of his wife. Wife's participation is very much essential in any religious rite. As we all know, wives are called ardhangani. So they are supposed to be given not only the importance but also the equal position with the men. But if we refer to the recent times in our society, it can be noticed that the position of wife is deteriorating day by day. The idea of sacrosanct institution of marriage is portrayed in India to be contrary, and it is far from women's perception of reality. Hidden under the iron wheel of marriage lies the ugly truth of crimes like marital rape, domestic violence, etc. Marital rape is still not criminalized in India, and thus there is no penalization for the same. This crime against women is a heinous type of crime. If we further move to the definition of rape and marital rape, we need to understand the rape versus marital rape concept. As we all know, there are two pillars of humanity: one man, another is women. In the development and growth of Indian society or every society, the development and growth of both men and women are necessary. Both should be given equal importance and equal role. But what is unfortunate in our Indian society is that women are always subjected to cruelty, disrespect, violence, discrimination, inferior status, and rape is one of the most appropriate example of this humiliation and atrocities committed against the women. If we move on to the definition of rape, as you all will be knowing that our erstwhile criminal code, Indian Penal Code, under section 375, the rape has been defined. And now under Bharatiya Nyaya Sanhita, the same definition is defined under section 63. And it is defined as a forced sexual intercourse without consent. If we see the offense of rape, it is the most heinous crime committed against women. If we move on to the marital rape, it is provided under the exception number 2 of section 375 and exception number 2 of section 63 of BNS, that states that sexual intercourse by a man with his wife, if she is above 18 years, 18 years has been amended by the Supreme Court in the judgment of Independent Thought versus Union of India. And if the sexual intercourse by a man with his wife and wife is above 18 years old, then it is not considered as a rape. So this is the difference our legislature has made between rape and marital rape. If a forceful sexual intercourse has been committed by a husband with his wife and wife is below 18 years, that is a rape. But if the wife is 18 years and above, that is not considered as a rape under Indian society. So if we see this concept of marital rape, since time immemorial, women have always been treated as a property or object of pleasure for men. They have been the survivors of crime of rape, sodomy, cruelty, harassment, etc. If we see in the current times, the rate of crime against women is hiking when the general public is fighting for their rights and fighting for providing them equal dignified status in the society. So, if we move further, let us discuss about the status of marital rape in Indian legal system. We can see that marital rape is a very complex issue. The term marital, when prefixed with the rape, serves to purify the crime and does not evoke the kind of sanction, legal and social as well, than it would otherwise. Rape, whether within or outside the institution of marriage, is the worst violation of any woman's human right that defiles her body as well as her soul. Yet, under Indian laws, husbands have been granted exemption from the criminal liability from charges of raping one's own wife who is above 18 years of the age. Hence, we can consider marital rape as ubiquitous yet obscure, meaning thereby marital rape is present everywhere in our Indian society. But the thing is, it is underreported, it is not seen by the society. The major lacking is the social fabric of our society, which is the major reason behind this decriminalization of marital rape. The reason behind is the male dominating society of our Indian culture. So if we move to the historical background or to the concept of this marital rape, this immunity of marital rape is the consequence of old notion of marriage that states that wife is regarded as only the property of her husband. According to the doctrine of coverture, a wife was deemed to have consented at the time of marriage to have intercourse with her husband at his whim. As per the doctrine of coverture, it is mentioned that when the wife marries a person, marries her husband, then she gives the consent for every act to be done by his husband, even it is against her or in her favor. So, moreover, this consent is known as the implied consent, which cannot be revoked. In 1736, there was a case where a 23 years old girl, filed a case against her husband for for having forcefully sexual intercourse with her. And at that time, the judge was Sir Matthew Hale, and he declared in his judgment that the husband cannot be punished for rape committed by him upon his legally wedded wife, as there exists a mutual agreement between them and a contract is between both of them that the wife has given herself to her husband, and this contract cannot be ever retract. So if we see that this 1860 act, the IPC, was formulated by British government, at that time this was the principle which was evolving, that the doctrine of coverture or consent in perpetuity. But but before this time also, our Indian society has not recognized the rights of women. They were considering the women as a property or as the object of pleasure for the women, for the husbands. So if we move further, this marital rape exemption is broadly premised on two assumptions, that is consent in perpetuity and expectation of sex. Consent in perpetuity is the assumption that on a marriage, a woman gives consent held by her husband in perpetuity, which she cannot retract. This concept in the colonial era has the roots in antiquated idea that a woman is the property of her man. And the second assumption, that is the expectation of sex, is that a woman is a duty bound and is obligated to fulfill the sexual responsibilities in a marriage, because the aim of marriage is considered to be the procreation of child. And since the husband has a reasonable expectation of sex in a marriage, the provision implies that a woman cannot deny it. So these are the basic two assumptions on which the marital rape exemption is based. So as we have also already discussed, that the exception 2 of section 375 of IPC and section 63 exception number 2 of BNS is dealing with this marital rape exemption. If we see the other provisions that are under our Indian legal system that protects the women from this heinous crime, are Protection of Women from Domestic Violence Act 2005, and various sections like section 354, 354A to D, 498 of IPC under A of IPC, and similarly section 75 to section 78 under BNS. But the thing is, the Protection of DV Act, which deals with the protection of women from the domestic violence, is only provides the civil remedy to the women. It is not providing any kind of criminal remedy except the remedy under 498 of IPC, and it is not recognizing the concept of marital rape. It only provides a civil recourse to women who are uh, under the under the acts of domestic violence. So, if we move on to the effects of marital rape affects women drastically. It is a misnomer that a woman being raped by her husband lives in a state of less trauma as compared to the woman being raped by the stranger. Rapist is a rapist, whether it is a husband or it is a stranger. This is actually a myth because woman being raped by her husband is in a more traumatic state because she has to live with that rapist, that is her husband, for her lifetime. It has been also shown by the research that marital rape has a severe and everlasting consequences for women because of the basic fact that rapist is no other person than his own husband. So, rapist is rapist. So, basically, there are two effects which we can discuss here: the psychological and physical. This heinous crime of marital rape affects the woman's psychologically. The woman who are raped by her husband lives in a state of trauma for whole of their life. These effects affects the life of women very drastically, leading to many lifelong problems like eating disorders, anxiety, depression, sexual dysfunction, and many more. And if we discuss the physical effects, the physical effects are the injuries to the private organs of the woman, fractures, bruises, fatigue, etc. So, these are the basic effects of the marital rape. The main reason behind the widespread gender inequalities are patriarchal norms of male dominating society, which are mainly leading to the suppression of women in our society. In our society, women have never been provided the equal status and are always considered inferior to the men. This principle of our society has given dominance to the men to the rule over women and has given the free end to exploit the women class. So, if we move to the constitutionality of this marital rape, as we all know that our Indian constitution is the grundnorm of all the statute, as it ensures equality to every person in our society. Whereas if we see the IPC or the new BNS, Bharatiya Nyaya Sanhita, it provides the arbitrary and not gender neutral laws for the women's. If we see the exception number 2 of section 63, it violates article 14 as well as article 21. Article 14, we all know it provides equality for everyone. The basic inequality which has been provided or which has been elaborated under this exception is that this marital rape exemption discriminate the status of married as well as unmarried women. In rape's definition or in marital rape definition, the basic discrimination is between the married and unmarried women. When a forceful sexual intercourse is committed with a woman that is not married, whether she is above 18 or below 18, that is a rape. But when it comes to the marital status, If a woman is below 18 years and a forceful sexual intercourse is committed by her husband, then it is a rape. But if she is above 18, then it is not a rape. So, basic discrimination or violation of Article 14 lies in this aspect. And Article 21 provides right to life and personal liberty. Every person has a right to live with dignity, and women has a right, has a bodily autonomy. She has a right to live with human dignity. So if a heinous type of crime is committed against her, then how can we expect her to live with a human dignity? So if these kinds of offenses are still prevailing in our society, we can not expect a woman to live with a human dignity. So that is why the marital rape exemption is viewed as unconstitutional in our Indian society. Then next, if we move on to the international scenario, firstly, I would like to discuss that the Britishers who have made our IPC, Indian Penal Code, who have legislated this rule, this marital rape exemption in 1860, they have criminalized marital rape in 1991. But India is still having this exemption. This is just because of the social mentality of our public. There are some loopholes that we would be discussing further also. But we can see that the Britishers who have legislated this exemption have criminalized this exemption a long back in 1991. And there are 150 countries in our world who have criminalized this exemption and have expressly made marital rape as a criminal offense, as a punishable offense. And if a husband commits a forceful sexual intercourse with his wife and the age is immaterial, he would be punishable under the law. If I quote some of the countries, UK, US, Australia, Canada, and most European nations have abolished the marital rape exemption. The first nation was Soviet Union, which has abolished this marital rape exemption. And UK, as I already told you, in 1991 has abolished this exemption. Australia has abolished in 1976, Canada in 1983. So we can see that developed countries have almost abolished this marital rape exemption. If we see the neighboring country, Bhutan, Bhutan has also abolished this exemption and criminalized marital rape in his own in its own nation. So if we talk about the international convention, the human rights occupy a significant place in the UN Charter. The preamble of United Nations Charter reaffirms faith in fundamental human rights and the dignity and worth of human persons and in equal rights of men and women. There are many provisions in UN Charter that signifies the importance of having equality, universality, human dignity, non-discrimination, from which we can conclude or we can signify that UN or international bodies are in the favor of having equal status to both men and women. If we talk about the international conventions, we have two major international conventions: CEDAW, Convention on Elimination of All Forms of Discrimination Against Women, that encourages that legal protection against all forms of gender-based violence. And the second is Declaration on Elimination of Violence Against Women, that calls for criminalization of marital rape. Then we must talk about Justice Verma Committee report. This is the most important and one committee report that has touched the issue of marital rape. as we all know about the Nirbhaya case, this committee was the result of that case. And this committee aimed to reform the laws on sexual violence. And we all have seen the major criminal law amendment act of 2013, which was the result of this recommendations. This committee has made the recommendation on marital rape also. But unfortunately, our legislature didn't agree to these recommendations, and still we don't have any law on the concept of, on the issue of, on the offense of marital rape. The major recommendation on marital rape issue were the first recommendation was to recognize marital rape as a grave violation of women's bodily integrity. The committee also recommended the removal of Exception 2 of Section 375 of IPC, and it emphasized that marriage should not be a defense for non-consensual sexual acts. The committee advocated for a rights-based approach, treating married and unmarried women equally under sexual offense laws. But these recommendations were left unaddressed by the legislature. Then next, we have the judicial attitude. As marital rape is one of the most inhuman decriminalized practices in India, which has resulted in various human rights violations against the married women, judiciary here has always played an important role in protecting the women's rights and establishing the gender neutral justice in a country where gender disparity is prevalent in almost all the sectors of the society. Not possible for the legislature only to empower women in such a male dominating patriarchal society. The drafting of legislations can be done by the legislature having beneficial provisions, but it is the judiciary by whom the laws must be implemented in such a way that it can provide justice to every individual with the principles of equity, justice, and good conscience in mind. The duty of judiciary is to interpret and apply the laws provided in the Constitution. The chief objective of the laws is to provide justice to the aggrieved. The judiciary scrutinizes all the provisions of the legislations, interprets them in such a way that the object of legislation is achieved, and then they are implemented in the proper places for the development of the society. So Indian judiciary, via its judicial decisions, has always held women to get what is due to her as a matter of her right, and it has been shown that violation of the rights of married women in Indian society would not be tolerated at all. Though the Indian judiciary has played a major role in protecting the rights of women in society, like providing them with property rights, right against sexual harassment at workplace, it has often been watchful about the rights of women in a family, especially in a marital relationship. The Indian judiciary has even taken a back step while coming to the issue of marital rape over the years. So, moving on to some of the Supreme Court observations, as previously also discussed, in the case of Independent Thought versus Union of India, the judiciary has amended the exception number 2 of section 375 and has raised the age of 15 to 18 years, and has also touched the concept of marital rape, and it has criminalized marital rape for minor wives, signaling a progressive approach. Then comes the Joseph Sign versus Union of India 2018, a very landmark judgment that struck down the adultery law and emphasizing the equality in marital relationship. Then we have the High Court judgment, High Court of Karnataka's judgment, Rishikesh Sahu versus State of Karnataka, which is still pending in the Supreme Court of India. This was the case where a wife has filed a case against her husband for having unnatural sex with her. So the High Court in this case has focused for criminalization of marital rape. And latest, we have the 2022 judgment the Delhi High Court split with verdict, where one judge favored the criminalization of marital rape, citing that there is a violation of fundamental rights of a woman, violation of right to privacy of the woman, and the second judge upheld this exemption, emphasizing the potential misuse and destabilizing the social fabric of our society. The next case we have is the X versus Principal Secretary, Health and Family Welfare Department, New Delhi, 2022 case. This this case is not primarily dealing with the marital rape exemption, but in this judgment, our former Chief Justice of India, D.Y. Chandrachud ji, has touched the concept of marital rape. In this case, there was the issue of medical termination of pregnancy of a rape survivor, of a live-in partner. In this case, the court has quoted that there should not be distinction between the married woman and unmarried woman for the medical termination of pregnancy. And if a woman is a survivor of marital rape, then also she should be allowed to have pregnancy terminated. So from this we can see that judiciary is playing a crucial role in the criminalization of marital rape, but there are some societal issues that are coming in the way to criminalize this issue, to criminalize this marital rape. So if we move further, then there are some arguments which are in favor of criminalization of marital rape, and also there are some arguments which are against the criminalization of marital rape. The whole discussion was regarding that there should be the criminalization of marital rape, as we have already discussed that there is a violation of women's dignity, autonomy, and equality if there is a offense of marital rape. And if the marital rape is criminalized, it would align with the domestic laws and also with the international human rights obligation to which India is signatory. And it also promotes the marital relationships if it is done. But the concerning issues are, as section 498 of IPC is being misused, so there is also a fear of misuse of this provision also if it is made. And also there is a practical difficulty in proving the consent within marriage. The major problem is the burden of proof, the burden of proving the consent. If it is made punishable, then how the consent will be proved? This is a matter of concern, this is the matter of difficulty. And center is also saying, even the various previous judges have also said that if marital rape is criminalized, then it would be having the potential impact on the family stability. It would destabilize the social fabric of our Indian society. So if we move on to the conclusion, if we see the broad concept of marital rape exemption, it basically undermines the constitutional principles and it fails to provide justice to the victim. Criminalization does not undermine marriage, but it strengthens the foundation based on mutual respect. So some of the suggestions are, we should amend our BNS to remove the marital rape exemption. Under Domestic Violence Act, the provisions must be included with regard to marital rape. Awareness must be provided and people should be educated so that the promotion of social understanding of consent and gender equality should be there. And Courts must ensure that they should adopt a victim centric approach, because in our society we are only focusing on the accused, we are not focusing on the victim. We always go for the accused. Accused has to be punished, accused has to be put in jail, etc., 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 but we ignore the victims. So we must adopt a victim centric approach. At last, the concluding line is only this, that this issue is more of a social issue. We all must to have this marital rape criminalized in our society. Firstly, we have to change the social mentality of the public, general public. If the social mentality with regard to women are changed in our society, then the marital rape criminalization is properly implemented in our Indian society. So that's all for the today from my side. Thank you so much. That's all. If anybody is having question, then they can ask.
Ma'am, there are some questions. Let me recite for you.
Yes, sir, please.
Ma'am, but the number of fake cases currently on a rise in our country. Is not it a possibility that if a law is brought up criminalizing marital rape, it will be used against men like the Dowry Prevention Act and Prevention of Domestic Violence Act?
Yes, this is the major issue now. Like I have already told that, like there is a misuse of Section 498 of IPC cruelty. Uh, the chances of misuse of this exception is also there. If this criminalization of marital rape is done, so there are chances that there would be a number of fake cases in our country. This is the reason our legislature is not legislating this law in our country. This is the main reason. So the main thing is we must focus on the social fabric of our society, so that there is there can be a balance between the both sides.
The next question is, ma'am, how can we counter Section 498 if it is misused? Hello, I am audible?
Yes, sir. Yes, sir.
Yeah,
uh, it all
the next.
depends on the evidence. The case rests on the evidence. So if the husband side can prove that with their evidences that this is not the case, then it can be proved.
The next question is, ma'am, have question mine is what are the regulatory challenges and implications for financial institutions operating in both banking and non-banking sectors under BNSS?
Can you please repeat the question?
What are the regulatory challenges and implications for financial institutions operating in both banking and non-banking sectors under BNSS?
Mm, is this question related to our topic?
No, ma'am, it is not.
Mm,
Okay, let me skip the question. The
mhm.
next is, then how can we trust it fully? There are fake cases.
Can you please repeat the question?
Like if you are explaining about two talk questions like about of fake cases against men or
Hmm.
misuse of 498. So it is a counter question like how can we trust it fully on the that law, because there are various fake cases have been registered by the citizens.
Uh, it all uh, it depends on the facts and circumstances of the case, and also the evidences provided by the parties, that how we can prove our case. So basically the lacking is on the part of our executive bodies. So if the executive bodies are powerful, then there are less chances of the cases to be faked.
And the next question is, how will the husband be able to get rid of the onus which is on his shoulders? He have to prove that he has obtained free and fair consent from his wife without any coercion before going for sexual intercourse with her.
This is the major difficulty in this law, that the consent, to prove the consent is very difficult. So this all can be proved through the circumstantial evidence the husband is having from the previous acts of his wife, from the subsequent acts of his wife, from the conduct of his wife. All these acts can prove that there is a free and fair consent.
Uh, the next question, ma'am, do you think making our criminal law gender neutral is essential while criminalizing marital rape in our country?
जेंडर न्यूट्रल के बाद क्या बोला था आपने?
Gender
वो
neutral is essential while criminalizing marital rape in our country.
Yes, gender neutrality is very much essential in our society, because uh, the word gender is not only covering the men and women, now it is also covering the transgender. So rather making it gender specific, rather making laws gender specific, our laws should be gender neutral, because every in our Indian constitution, every person is protected. It is not for the men, women, or anyone. It is for everyone. So it is better to have a gender neutral laws rather than a gender specific laws.
The next question is, ma'am, how can men do anything wrong with wife in terms of sexual relationship? If the same thing happens with men, then what? Ma'am, please elaborate.
uh, this is again a issue in our Indian society, that there are no laws concerning the male persons in our Indian society. If a man is aggrieved, in case he can have recourse to various other provisions provided under our Indian legal system. But if we say that, is there any law that is concerning with men only, then the answer is no. But the man can have recourse to various other legal provisions under our Indian legal system. Mm. Can we have the further questions through mail, because I have to leave?
Sure, ma'am. If we will provide the mail ID of speaker in the WhatsApp group, and you
Mm.
can ask the if those you have any questions, you can mail the questions to her. Now, just give me a second. Audible to all of you, na? Hello, I am audible, na? Yeah,
Yes,
thank
sir,
you.
you are audible.
Give me just 2 minutes, man. Then we will wind up the session. As we come to the conclusion of this insightful and engaging webinar on marital rape exemption in India, it is my pleasure to extend a heartfelt vote of thanks to all of you for being a part of this session today. First and foremost, I would like to express our deepest gratitude to our esteemed speaker, Ms. Rupali Sharma ma'am, for sharing her wealth of knowledge and expertise on this deeply significant and sensitive issue. Your insightful analysis and thought provoking perspectives have provided us with a comprehensive understanding of the complexities surrounding marital rape exemption in India. We are truly inspired by your words, and grateful for the time and effort you have invested in enlightening us on this critical topic. A special thanks to all our participants for your active engagement and thoughtful questions. We hope this session has not only increased your awareness of this pressing issue but also motivated you to contribute towards a more equitable and just society. Once again, thank you all of your presence, and we look forward to present seeing you at our future events. Have a wonderful day ahead. And please stay. I will be providing the WhatsApp group link plus feedback form link also. And the feedback form link will be deactivated at 6 p.m. Thank you so much. And thank you, ma'am, for taking a wonderful session.
Thank you so much. Thank you.